The Supreme Court decision in AAR versus Tiger Global marks a significant moment in India's international tax jurisprudence, reopening long-standing debates around treaty certainty, grandfathering protections, and the limits of substance-based scrutiny. By allowing tax authorities to look beyond tax residency certificates and examine effective control, management, and commercial substance at the threshold stage, the ruling has raised important questions about the future of the authority for advanced rulings, the boundaries of GAAR, and the balance between investor certainty and anti abuse enforcement. To unpack the broader implications of this judgment, we are joined by Justice Ravindra Bhat, former judge of the Supreme Court of India, and Mr. Rajiv Ahuja, founder and managing partner of Synergy Lex. To begin with, Justice Bhat, I would like to ask my first question that how should courts reconcile certainty promised by grandfathering clauses with the need to curb abusive arrangements? And can grandfathering ever be absolute, or must it always remain conditional or genuine commercial substance?
You see, the object of a double taxation avoidance agreement, or DTAAs as they are called, is to ensure that a tax subject whose income and activities may be straddling in different or globally, different economies or globally, is not made to pay tax twice over. So in this, but at the same time, there's a kind of tension among the tax authorities of various countries, because depending on how they view the generation of income and the location of the activity, they may want to have a bite of the same pie, not one time but multiple times. So in order to lay down the ground rules, we have these tax treaties, double taxation avoidance agreements as they are called, and they generally lay down different principles, and they have different classes of income for which different rules are applicable. At a global level, you have the UN, which is also a platform, and then we have the OECD, which comes out with its own drafts. Of course, India has not been a party to the OECD, though we are formally part of the UN exercises. Now, if we keep this broad objective in mind, as to the second part of your question, which is, uh, can grandfathering ever be absolute, or must it always remain conditional on genuine commercial substance? I can only say this is a matter of policy. So you see, you have tax treaties by one nation which enters into tax treaty, like in the case A enters into a tax treaty with B, saying that my subjects or your subjects will equal. Basically, it's laying down the ground rule which applies equally to both tax subjects. So, if in the part of the negotiations they have a grandfathering clause, and there was no grandfathering clause in this case, and then a protocol was negotiated between India and Mauritius in 2016. This got notified in 2017. Correct me if I'm wrong, Rajesh. So in this, for
So
the
it is
first
the
time,
same date.
they in this for the first time, the protocol brought in a grandfathering clause. Now, the grandfathering clause itself may pose a limitation, in the sense that the absence of a grandfathering clause, does it enable the authorities to look into a transaction or beyond a transaction? So those are questions which arise from this judgment. And the Supreme Court has taken what tax practitioners see as a radically different route. It has kind of deviated from its interpretations in the past. So the reconciliation of certainty, because tax avoidance treaties as essentially a regime where the tax subjects, which is somebody from investor A country, uh, is going into the host country B, and he wants to make sure that these are the ground rules, maybe the rate, the conditions for withholding of tax, and what is the a particular subject matter of tax. When we're talking of capital gains, what is a capital gain, what is a royalty? These are all ground rules laid down in the tax. So now, how should this be reconciled? I would say that it again depends on the terms of the treaty, uh, because the overall effort of the court has been to ensure that the the wording and the text of the treaty is kept faith with. Therefore, we have one of these seminal judgments, an old judgment, Azadi Bachao Andolan, which incidentally also arose in the context of the Indo-Mauritius Treaty, which laid down a three-tier test as to how you look at income and whether it's taxable in India or somewhere else. The first rule was whether that activity is taxable. So the second, taxable. If so, what are the provisions in India? And secondly, if that is the subject matter, and then onwards, how is it dealt with in the treaty? If there is treaty, if the treaty also deals with this, and the terms of the treaty are categorical, then the treaty prevails. There is primacy of the treaty. So this was and this has been largely the way the courts have interpreted the tax treaties all the while. So whether this needs to be reconciled with interpretation, I don't think uh, there's any doubt that since these treaties are meant to provide certainty, courts generally always honor it. uh, I mean, for this one Tiger Global, I'm sure you can find at least 100 judgments where treaty primacy has been actually given effect to. So I don't think there can be any two answers. Treaty certainty has to be given effect to.
Right, right. Thank you so much, sir, for explaining this so well. Uh, Coming to you, Rajiv ji, post-Tiger Global, can any advisor still treat a TRC as a serious shield, or has it be merely a starting point?
I think, Bhumika, the Tiger Global settles these questions quite decisively. A residency certificate is no longer the end of the inquiry. The court has categorically stated that it's the entry point, it's a beginning, but you need to satisfy other conditions. The importance has been given to the substance rather than the form. It's an eligibility condition. If we read section 94 of the Act, which says that TRC is the starting point, it's eligibility to go into the treaty. First, I need to go and see my taxability in the domestic tax laws. Then I need to go and see the benefit available to me under the treaty. So to get into the eligibility condition, the first point is the TRC. It cannot be a shield, a blanket shield. So now it's a point that where everybody stop stating the TRC as a shield.
Okay.
It's an entry credential, but necessary, but never sufficient. Yes, in my view, the TRC it's matters, but so do the commercial substance, decision making autonomy, consistency of conduct, and economic risk assumption. This is not judicial hostility to treaties. The judgment make it very clear that treaties are meant to avoid double taxations, but not to facilitate avoidance. So at this point, the substance become very important. In another words, if I would like to say it, TRC can be considered like your driving license, but it does not permit you the rash driving.
Right. Thank you so much, Rajiv ji. Justice Bhatt, coming to you again, do you see this judgment as reimagining the AR's role, transforming it from a facilitator of certainty into a first-line institutional filter against abuse?
I don't think we should view the AAR as AR's role as a facilitator. After all, when you go there, the applicant, which is the company concerned, wants to know what are the implications of my entering into the market, what are my rights, and what is my taxable, exposure. So therefore, the AAR is a specialized body. It has always been a specialized body, and it comprises of fairly senior, very senior officials now. Earlier, it used to be headed by a Supreme Court judge. So it's not that, and you consider the fact that the AAR's decisions are final. Am I right, Rajiv? They are
Absolutely,
deemed
sir.
final. They can be challenged. It final both for both the parties, the revenue as well as the taxpayer. So this means that the AAR is an authority, which means it's an expert body. Although its view is termed as an opinion, but the decision actually is binding. Therefore, we to consider that it's a facilitator, mere facilitator. It answers questions. When it answers questions, it may be saying yes, you are not taxable, or no, you're not. Therefore, they're charged with the duty of applying their mind to the existing laws. So this is what I wanted to clear at the outset. Yes, now, if previously TRCs were viewed in a particular manner because of historical reasons, which is the judgment of the courts. We had, I think, uh, Azadi Bachao Andolan as well as Vodafone, which fostered that kind of thinking that TRCs are more or less conclusive. So now, with the clarification provided by the Supreme Court that TRCs are an entry point, they are only an eligibility condition. And let's not forget, in this case, the AAR actually opened the gates and said, I am going to inquire into the substance. And the AR had declined the application. It was the High Court which set aside and said that you are entitled to tax exemption, whereas it was the AR. So therefore, the AR's role has been in that sense clarified. I won't say that a new role has been thrust on AR. The AR is seen as a fresh entry point to say that yes, please look into it. I have a duty to look into it whether this this kind of substance is taxable or not, so that when you do your tax planning, you are aware, right? So you go to the methodologies, you go in advance and post this query that if I do this, would I be? But they here, of course, they transacted and then went to the AR. Yeah.
Right, right. Thank you, sir. Rajiv ji, do you think this ruling will discourage applications to the AR, especially for complex cross-border structures?
Bhumika, in my view, it may discourage some applications, but I would argue that it will significantly improve the quality of those that are filed.
Mhm. Okay,
The court, in its judgment, make it very clear that AAR is entitled to reject the application at the threshold. The threshold which has been set is prima facie, not a detailed one. So if a transaction, an arrangement, or a structure is not able to pass that prima facie test, that it is not for avoidance, then I think the
right,
genuine application will stand there. AR is basically was established, an institution was established to give the certainty. Like Justice Bhatt has said that it's for the pre-structure. I want to propose this structure. What would be the taxability of it? Before the bringing that structure into place, you go to the authority and see what is the standpoint. So now going post, only the genuine transactions will stand there. The substance will be given importance, and again the institutional integrity has been established that they have the right to dismiss, reject the application prima facie if it is for the purpose of avoidance. Avoidance of tax is not permissible at all. So yes, I agree with you that it will discourage some applications, but
right,
this judgment does not closing door. It has just only raised the bar, the eligibility.
right. Thank you so much, Rajiv ji. Justice Bhatt, is there a danger here of normalizing GAAR-like reasoning outside GAAR itself and thereby diluting the statutory architecture which Parliament carefully designed?
Now that's a kind of a complex question because We have a GAAR-like provisions in the Indo-Mauritian protocol, which was entered into in 2016. So I think it's 27A, Article 27A, which specifically stated that it is possible for tax administrators to look into the design of the uh, transaction in order to see whether it's a merely a device. Now, there are also quantitative threshold restrictions which help the tax administrators to decide whether an entity is merely a shell entity and has created a device in order to avoid tax liability. But the danger here is, yes, there is a concern. There could be a concern because we have the grandfathering clause in this Indo-Mauritius treaty, and B, we have the GAAR-like provisions in this treaty itself, 27A. Now there are treaties and treaties because we have a large number of treaties with several countries, which may not have either of these, either the grandfathering or the you know GAAR-like provisions. The question then is, how does the court, how would the tax administrators react to this? So the Indo-Mauritian one has given one clear view that a GAAR-like provision cannot be ignored. It's part of Indian law. Even though it may not be factored into a treaty going forward, it is quite possible that even though it may not be factored into a treaty, the courts and tax administrators nevertheless may look into this and decide whether the substance of a transaction is a device in order to escape tax. So whether you can call it as loss of treaty certainty or a measure to stop abuse is a matter of perspective, because treaty shopping is always frowned upon. You, why do you want to immunize taxation, or rather give the assurance that we'll give you this particular tax treatment in our treaty, in our jurisdiction? You want genuine transaction, genuine businesses, not those kind of businesses which merely are using your route in order to, escape some kind of taxation. So this is a kind of wake up call, because the transaction here uh, related to a company which was incorporated in Singapore, but its substance of its holdings, its economic activity, everything happened in India. And therefore, and then at the other end, those Mauritian entities for the TRC purposes were definitely Mauritian, but the control, the court concluded after detailed analysis, was not in Mauritius. So they were literally created for the purpose of, let's say, taking advantage of Indian tax laws. So, in other words, GAAR-like provisions could play a role in future. It's a bit early now, but going forward, it's quite possible that tax administrators would use their magnifying glass more carefully.
Right. I think it's a very early stage for GAAR-like principles to apply at the moment. Uh, Thank you, sir, for explaining this so well. Rajiv ji, does this ruling weaken those procedural sheets by allowing GAAR-like logic to creep in at earlier stages?
This is a legitimate concern, Bhumika, and it is one that industry is raised consistently. But I do not read the Tiger Global as collapsing GAR into every procedural stage. What the court has specifically said that it's a prima facie at the entry stage, not full-blown adjudication. Very categories it has been held by the court that it's not full-blown adjudication of the GAR-like provisions. The GAR threshold, its procedural requirement are still intact. If GAR has to be invoked, then it has to be go as per the rules and the provisions provided under the law. Only for this AAR, the prima facie opinion has been held, which raises a very good question. that before accepting any such application, the authorities had been asked on a prima facie basis, does this application has any merit at all? Does it need any analysis at all? That's it. So this, it's not like that it's GAAR provision has been overblown or the rules have been overpowered. It's a prima facie only. If I put it in another words, every fever does not need a surgery, but you need the thermometer. You need to check what is the status of the patient before doing any analysis. So it's procedural arbitrage, which are some people are using it, going to the AR, has now shifted for the legitimate defense. If you have a legitimate, your control, you the structure or arrangement is able to speak itself, not on documents.
Right,
There is no
right,
problem at all. I don't see any problem.
right. Thank you, Rajiv ji. Justice Bhatt, is there a risk that strong observation at the jurisdictional stage may preempt or prejudice the merit stage adjudication?
Well, the judgment of the Supreme Court is authoritative, but I think our tax administrators are mature enough to uh, they take that only as a caution and a warning, and not be completely overawed by it, because there have been so many instances. For instance, when a uh, when a tax subject, when an assessee is confronted with a reopening of assessment, usually it's challenged before the courts. The courts may make strong observations, but that doesn't detract from the fact that the assessing officer, who is at the lowest rung, will look into the entire transaction, each entry by entry, and see whether this qualifies or doesn't qualify. So strong observations may not lead to blanket inclusion or, you know, higher thresholds of taxation. So therefore, everybody knows his duty, and our system is pretty robust. We have an income tax appellate tribunal, the oldest tribunal in the country, which is, I think, celebrated about 90 years or so, more than 90 years. And our the revenue service, we have good officers who can sift through all this. And I don't think there should be a alarm bell should not be ringing at this stage. So as we go forward, we should see how how this interpretation is sinking down, and how it is being taken at the lowest and middle levels.
So, you just mentioned that there's a possibility of different interpretations. So there is always a bell, or there's always an alarm which might the reason why there is so much of debate on this, that the interpretation is possible, and why the advanced tax authorities and there is a concern which is coming, that whether they will apply the Supreme Court judgment as it is or not. What do you have to say on this?
I think, Bhumika, as with any judgment, or maybe even more so in the case of taxation, it's a daily evolving field. When anything new is brought in, any new concept is brought in, a lot of uh, debate, hot debate ensues. I remember, for instance, we had the transfer pricing, concepts being introduced,
Right.
and till the safe harbor provisions came in, there was a lot of angst about the ways interpretations were happening. But all that is over. Things have settled down. Likewise, at the initial threshold, there was, let's say, uncertainty and confusion when we looked at, then we had Azadi Bachao Andolan, and Azadi Bachao Andolan judgment. Then came Vodafone, which was a kind of a which gave us a different way of looking at all this. It said that there is no question of looking into, but look at the transaction. So we looked at transactions, but now after GAR, and I think that's where the court has made a point, that after GAR-like provisions and after the protocol, let's not take everything for granted. We will have to look into, and mere looking at, which is just accepting the TRC for what it stands is not sufficient, because the law, domestic law has changed, and correspondingly, the treaty also has ensured that there is a way of looking at it. Because the world now has agreed that double taxation avoidance agreements should not be a device to escape taxation. So this concern has led to GAAR. Let's not forget that. Therefore, why should tax authorities not look into transactions which seem to be dubious? And if they are meant to, let's say, I want to use strong words, if they are meant to evade taxation and ensure that no amount is paid towards the tax jurisdiction of one country, you pull it back and ensure that the relevant tax is paid. Because you
Right.
can't allow someone to take advantage and not, not be subjected to tax. After all, there is a parity of, there's an equality. You come here and transact on the same terms as others. Maybe you are more fortunate because of whatever negotiating terms are. If the Indian entity is paying let's say 25% taxation, you may pay only 10%, which is what the double taxation avoidance agreement may ensure. But if you want to escape it completely, why should the Indian authorities not look into it at least?
Right. Right. Thank you, sir. Uh, Rajiv ji, where do you see the real battle ground shifting to assessment, DRP, high courts?
In my view, now the real battle is shifting decisively to the assessment stage.
Okay. Okay.
After this judgment, when the emphasis is given on the substance over the form, the court has very categorically stated that where the control lies, where the decision is taken, where the person is residing, in which country, it's not a shell transaction. So it clearly shows that now the all the persons who are coming must be ready to play the chess not on papers, rather on the board. That is before the assessment. DRP is there, again a fact finding authority. So first, at the very first stage, you need to bring all the facts at the assessment stage. Then the matter
Right.
will go to DRP. Then the appellate tribunal is there, which just recently on 3 days back celebrated 85th Foundation Day in Delhi. It's a very huge gathering, and remarkably, the tribunal, the oldest tribunal in India, rightly said by the sir, is functioning so well, even at procedural or even at decision on the fact. Now, the jurisdiction of the High Court will remain on procedural fairness or jurisdictional issues. But
Right.
ultimately, the facts, the substance need to be established at assessment stage.
Right.
The
Thank you.
assessees
Thank you,
bring
Rajiv
the
ji.
sure.
Rajiv, Justice Bhat, what is your final thought on this judgment? And do you see Tiger Global as recalibrating India's narrative from treaty certainty to substance-based legitimacy? Final thought on the judgment.
I would say that some of the principles which the court has reiterated may seem novel or a departure from what our businessmen and tax administrators have been used to. But at the same time, it is kind of it's telling us, judgment tells us that look, don't look at how business has always been done. Just don't look at the tax residency TRCs and close your eyes, because the law, even treaties now require you to look closer into the transaction and see whether the substance of it is geared to is a device created in order to escape taxation. So I don't think we have to be unduly alarmed as far as genuine transactions are concerned. The court has made it very clear it's only an entry point, but that doesn't mean that genuine transactions will not get the benefit of treaties concerned.
Right. Thank you, sir. Thank you so much. Rajiv ji,
Welcome.
what is your final thoughts on the judgment? And also, does Tiger Global increase India's risk, or does it simply formalize what was already implicit under GAAR?
I do not believe that Tiger Global increases India's risk. It clarifies India's risk framework. Because if we read the opinion by Justice Pardiwala, it's specifically talk about the sovereignty that India has its right to tax. So it just clarifies. It is GAAR is now part for our provisions for law for years. What was missing was a judicial confirmation. By way of this judgment, this confirmation is there. Court, the Supreme Court clearly states that TTs are not instruments for avoidance, and the Parliament has authority to recalibrate what was not there. So it's a confirmation comes from the courts. Now, this judgment does not penalize the investments. It penalizes the structures that cannot explain themselves. What has been given is you cannot come to India and say this is finally on the documents. You need to come with a commercial honesty. If person is coming with a commercial honesty and structure is able to explain itself, then I don't think that it increases the India's risk. Rather, it gives a certainty. All the genuine investments are welcome with the commercial honesty.
Thank you. Thank you so much, Rajiv ji. And thank you, Justice Bhat and
Thank
Rajiv ji,
you.
for deeply illuminating discussion. What clearly emerges from our AR versus Tiger Global is not just a ruling on treaty interpretation, but a broader recalibration of India's international tax framework, one that seeks to balance certainty with credibility and investor confidence with institutional integrity. Thank you so much, both of you, for giving your time today. And very quick discussion, but I think we covered all the major points today. And thank you again for giving your time.